Hey everyone, welcome back to the channel. Today we'll explore an important aspect of bankruptcy law in Singapore, the role of trustees in bankruptcy under the Insolvency, Restructuring and Dissolution Act of 2018. Whether you're going through bankruptcy proceedings, a business owner, or simply curious about insolvency law, this video will break it down for you. Let's start with the basics. A trustee in bankruptcy is the person appointed to manage the assets of a bankrupt individual. What's their primary goal? To ensure the orderly distribution of the bankrupt's assets to creditors. In Singapore, the role of trustees is governed by the Insolvency, Restructuring and Dissolution Act. Trustees in bankruptcy act as fiduciaries, meaning that they must act in the best interest of the creditors and follow legal obligations strictly. Trustees can be the official assignee, which is the government office, or a private trustee approved by the court. Section 36 to 46 of the Act outlines the framework for trustees in bankruptcy, including the appointment, their powers, duties, and the liability of trustees. The bankruptcy rules provide procedural guidance on how trustees should conduct their duties. Trustees must adhere to ethical standards, avoiding conflicts of interest and acting impartially. Now let's dive into what trustees actually do. Firstly, Section 39 of the Act states that trustees in bankruptcy have all the functions and duties of the official assignee in relation to the conduct of a bankrupt and may exercise all or any of the powers of the official assignee in relation to the bankrupt. Accordingly, they have the power to take control of the bankrupt's assets, including identifying, valuing, and safeguarding assets. They have to ensure assets are distributed fairly, following the order of priority set out in the Act. Secured creditors are paid first, followed by preferential creditors and then unsecured creditors. They also oversee the discharge process, ensuring that all legal requirements are met before the bankrupt is released from his obligations. Managing a bankruptcy is no small feat. Trustees in bankruptcy face challenges such as tracing and valuing overseas or hidden assets. They also have to balance the interests of secured and unsecured creditors, which is often tricky. They also have to deal with uncooperative bankrupt individuals, which adds another layer of complexity. Let me share some thoughts on the role of trustees in bankruptcy. Trustees are the backbone of the bankruptcy process, ensuring fairness and transparency. However, their success largely depends on collaboration from creditors, debtors, and the legal system. Singapore's Insolvency Act provides a robust framework, but like any legal system, its effectiveness relies on how diligently stakeholders fulfill their roles. For individuals facing bankruptcy, my advice is simple: cooperate with your trustee. It's the fastest way to resolve the situation and move forward. Thank you for joining me on this video on trustees in bankruptcy. If you found it useful, don't forget to like, share, and subscribe. And if you have any legal questions or topics you'd like me to cover, drop them in the comments below. Until next time, stay informed and take care.